All right, hi everybody. We're just going to give it a minute or so for people to join and get situated. All right, why don't we kick off? We may have some more people joining, but we've got a lot to talk about. So let's get started. Good afternoon and good morning to folks on the West Coast. Thanks very much for joining. We think this is a pretty timely webinar entitled Social Media Challenges and Opportunities in Free Speech. It's sponsored by the ABA section of Civil Rights and Social Justice and the CBA section on Constitutional and Human Rights. This panel is the second in a series addressing critical issues relating to free speech on both sides of the US-Canada border. And in my best NPR voice, we are planning additional programming on a variety of issues, so please visit americanbar.org/CRSJ for updates on these programs. During today's program, we encourage you to ask questions of our panelists. Please use the Q&A function, not the chat function. If you can't see it, just move your mouse around. Your screen might be idle. And we'll address questions during the program. So we'll be sharing a recording of the program as well to everyone who's registered, and feel free to share that with your networks. So before we begin, we want to start by actually asking some questions of our audience. So you should see a poll question pop up, 2 questions actually. The first is, we want to get a sense of who you are, and your interest in these issues. So are you a lawyer, student, academic, non-lawyer advocate, or something else? We should see results shortly. Great, so we've got a lot of lawyers, some students, and just closed out on me, but some other folks as well. So thank you for joining. We have a second question, which is, we'd like to know, do you reside or work in Canada or the United States or somewhere else? This is to help us determine the appropriate number of hockey references we should be making throughout the program. Great, so we've got a pretty good even split here, about 40% in Canada and 55% in the US. So thank you for joining, and thank you for your participation. So we're thrilled to bring you this program, and as I mentioned, an especially timely topic. As our audience will know, while social media platforms are not required to comply with the First Amendment, as they're not government actors, there are interesting questions about whether those principles should apply to the platforms, and if so, which ones? Social media, on the one hand, amplifies free speech in the public square, and with that comes great opportunities and challenges, so hence the title of our session today. I'd like to turn it over now to our co-moderator, Heather, north of the border.
Thank you, Claire. Hello, everyone. Welcome to this second webinar of our 3-part series, exploring comparative analysis of free speech in Canada and the US. I am Hettiarachchi, Principal of Integritas Workplace Law and Chair of the Canadian Bar National Constitutional and Human Rights Law section. I'm joining you today from Vancouver, British Columbia, from the traditional and unceded territory of the Coast Salish peoples, including the Tsleil-Waututh, Squamish, and Musqueam First Nations. Our section's mandate includes examining issues relating to the Canadian Charter of Rights and Freedoms, constitutionality of government legislation, the division of legislative powers, and human rights. We are very excited to be presenting this very topical webinar to you in collaboration with the ABA section of Civil Rights and Social Justice. And I particularly want to thank Angela Scott, chair of the CRSJ, who was very receptive to the idea of other sections collaborating on this initiative when I first reached out to her in September of last year. And also, I want to thank Claire and Steve Vermeer, co-chairs of the Free Speech and Free Press Committee of the CRSJ, for making this happen. And now I will turn it over, Claire, to introduce the US speakers.
Great, thanks. So we're really excited today. We've got Michelle Alston joining us from Twitter. She is the head of public policy for Canada for Twitter. And we've got Paul Barrett, who is the deputy director at the NYU Stern Center for Business and Human Rights, adjunct professor of law as well at NYU School of Law.
Thank you. And I'd like to introduce the speakers from Canada, Vivek Krishnamurthy and Taylor Owen. I have slightly longer descriptions for our speakers. Vivek Krishnamurthy is the Samuelson-Glushko Professor of Law at the University of Ottawa and Director of CIPPIC, which is the Samuelson-Glushko Canadian Internet Policy and Public Interest Clinic. Vivek's teaching, scholarship, and clinical legal research practices focuses on complex regulatory and human rights-related challenges that arise in cyberspace. Vivek advises governments, activists, and companies on the impact of new technologies on human rights, and is a frequent commentator on emerging technology and public policy issues. In addition to his roles at the University of Ottawa, Vivek is currently a fellow at the Carr Center for Human Rights Policy at the Harvard Kennedy School and a senior associate of Human Rights Initiative at the Center for Strategic and International Studies in Washington, D.C. Our other speaker, Taylor Owen, is the Beaverbrook Chair in Media, Ethics and Communications and the founding director of the Center for Media, Technology and Democracy at McGill University. Taylor is also an associate professor in the Maxwell School of Public Policy at McGill. Taylor's work focuses on the intersection of media, technology, and public policy. Taylor sits on the Governing Council of the Social Sciences and Humanities Research Council, is a senior fellow at the Center for International Governance Innovation and a fellow at the Public Policy Forum. He is also the host of the Big Tech podcast. Taylor has authored several books relating to the topic of the digital age and state, and his latest book on the subject of Silicon Valley journalism and democracy, which he is co-authoring with Emily Bell, will be published by Yale University Press later this year. Welcome, and thank you so much for agreeing to share your expertise with us today. I will now turn it over to Claire to introduce herself and to kick off the panel presentations.
Thank you, Heather. So I'm Claire Rajan. I'm in Alan Overy's Washington office. And as Heather mentioned, I serve with Steve Vermeer as co-chair of the Free Speech and Free Press Committee. I also spent a number of years litigating First Amendment issues at the Federal Election Commission and regularly advise clients now on these types of issues in election law, government ethics, and political law. So let's get started. We'll have our panelists just present for a few minutes each and then open up for debate. So Paul, why don't you kick it off for us, please?
Happy to. Thanks for having me to this great panel. I guess I'll offer two quick dispatches on social media and free expression. One concerns platform self-regulation, and the other one potential platform regulation by government. On the self-regulation front, we've had a very important recent decision by Facebook to suspend Donald Trump for 2 years, and accompanying that announcement, a policy change whereby Facebook will now actually review and apply its standards to politicians more generally, whereas previously Facebook did not. All of this came, of course, in response to a ruling by Facebook's oversight board, which said that Facebook was justified to suspend Donald Trump after the January 6th insurrection at the US Capitol, but that the company had failed to justify an indefinite suspension, and that such an indefinite suspension was not part of the rules beforehand, so therefore the company had to come up with another justification and another punishment. Question, what to make of this? I think a couple of observations that are potentially useful are this underscores the unique role of Facebook's oversight board, this really sort of extraordinary creation of the company, populated by some people of very impressive credentials who are clearly taking their job very seriously. And I think one of the big themes that runs through the oversight board's work so far also animates its role in connection with Trump, which is to say, holding Facebook, the company, to enforce its rules consistently and to make its rules understandable in the way that a US court, when confronted with a vague statute, might conceivably say that the statute could not be applied to a particular litigant because it's vague. And the oversight board is clearly going to demand more of Facebook, and we'll see whether the company complies with this, but conceivably it could end up resulting in the company's reworking its community standards in a way to make them much more consistent than they are now. A second, I think, growing out of this is a very practical ramification for the company itself. I think we should all notice that in conjunction with ruling on Trump, Facebook undertook a really big new obligation and responsibility to review the statements on its platforms of politicians and public figures more generally. Previously, of course, Facebook had said that as a matter of free expression, it would not look at what politicians say. Now it will. That is almost certain to lead to all kinds of controversial decisions if the company takes this seriously. Politicians are, of course, notorious for bending the truth, making offensive comments and so forth. And how Facebook will manage this huge new obligation, I think, is something that deserves a lot of attention. And I think people should think also about the fact that the company is setting aside its previously articulated a dedication to politicians' speech being untouched, unregulated, because it was newsworthy. That apparently is largely out the window. On the government regulation front, fans of the United States Congress probably already know that there are a couple of dozen bills pending that would, in one way or another, affect the operations of social media platforms. Most of them would amend in one way or another Section 230, the liability shield that currently protects those platforms. Others would mandate more transparency and accountability. And I think the observation to make about all of that is that Congress is most likely to focus on Section 230, but we might want to ask whether that's actually what should be the top priority. My center at NYU, the Center for Business and Human Rights, has put out a series of recommendations concerning regulation of social media platforms. And we argued that while Section 230 does deserve to be amended to create new incentives for more vigorous content moderation, that actually the top priority should be trying to figure out some type of more affirmative regulation by the government of social media platforms that have not to date adequately regulated themselves. And the one way to go about that would be to authorize the Federal Trade Commission to oversee the operation of social media platforms, not to superintend content decisions, but to make sure that the right processes and disclosures are made and that the platforms live up to the promises they've made to their own users. So I think we're going to put our recommendations in the chat, and you can look at them in more detail, and I'd be happy to answer questions about them.
Fantastic. Thank you, Paul. We'd love to hear Michelle's view on that as well.
Hi, everybody. Thank you very much for the invitation to appear today. My name is Michelle Austin. I'm the head of public policy in Canada, and I've actually recently taken on a number of U.S. managing responsibilities for policy. So throw all of your Canada-U.S. questions at me, and you can at me on Twitter. It's @_Michelle Austin. In the spirit of the platform, I would like to acknowledge that I'm coming to you from unceded Algonquin territory in Ottawa, Ontario, Canada. And for those with visual disabilities, I just described that I am a light-skinned female with long dark hair, wearing a black shirt with pink flowers in front of a white room with shelves behind me. There's a few things that I wanted to touch on, Paul. My gosh, some of those were great. I hope we get into the nitty gritty of those. I wanted to just explain sort of a little bit of my role with regard to legal. I'm part of Counsel at Twitter, and it's very similar across any social media company. That's usually legal, public policy, trust and safety, and compliance. And we do tend to work cross-functionally on a number of issues that will probably be discussed today. I did want to also talk about Twitter. And make sure that we distinguish that each platform is very different. Each type of service is very different, although when regulators and legislators, especially elected officials, start talking about it, it does sound like one big, giant industry and approach, which it's not. So, each service exhibits distinct features in relation to what it delivers, and then, naturally potential litigation and the reasonable steps that can be taken by each platform in order to prevent the distribution or amplification of content. So Twitter is different because it's public. You don't have to ask to follow anybody on Twitter 99% of the time. It's out there. Twitter is fast. Oh my gosh, it's fast. And so we have to be able to act globally pretty quickly. And Twitter happens in real time. So all of those are sort of to be taken into consideration as we talk about this approach, right? And another example is encryption. We have no encrypted product, but Facebook is moving completely towards encryption. We're very much an open source platform. So as legislators and regulators and litigation teams think about this, we do have to think that there are really distinctions in platforms. And Taylor is here, and he will tell you that we have an open API. So we are very open in terms of research, because he cites all of our data all the time. And other companies really do not. So there's really big differences in how we approach things. I want to speak quickly about free speech, and then just a couple of things from a legal perspective, what I absorbed from the legal team. So Twitter's very honored to be the home of so many social and justice movements. I probably don't have to repeat it. The Me Too movement started on Twitter. If you want to know what's happening in China and Hong Kong, you go to Twitter where it's permitted. The government of Nigeria has just blocked us on Twitter. So we are at the heart of all of these conversations about free speech and human rights and justice in real time. The old adage is true, free speech isn't free, and we're very aware of it. It's something that needs to be loved and cared for and discussed and taught. And the same would also apply to democracy, which is one of the outcroppings of free speech. So this is something that's baked into our DNA as we deal with it every day. Then I just wanted to discuss briefly some of the things that cross my desk from a legal perspective with regard to free speech. And I'll start with where Paul also was talking about, which is intermediary liability or content takedown, depending on how you interpret it. Section 230 in the US, common law in Canada, and then of course we have the United States, Mexico, Canada Free Trade Agreement, which also has a clause on that. So it's not really very clear from a jurisdictional perspective. So it's very interesting for us to have to deal with this globally. Add in anonymity and all of those other things to spice it up, and you've got a lot of fun. So the interesting thing is that oftentimes these issues are thought about in binary solutions, right? Take up or leave down, and there's no in between. We have been arguing more recently for some context and choice with regard to how we talk about free speech. And one of the biggest things that we talk about is labeling, which of course you saw in the US election with Donald Trump. In our extensive consultations with our users, they said, you know what, we don't really want you to make a lot of these decisions for us, but we'd appreciate some context with these. So as we go through and discuss intermediary liability, we are talking about amplification and context and labels and all of these other, in many ways, product solutions that will help individuals make their own choices about what it is they are seeing. The second issue I wanted to talk about was what I call the notion of proxy. Free speech is tough. It's a tough issue, and it's often an issue that governments shy away from. They don't want to be the ones making the decisions on to whether or not something is appropriate or not. And so what we've been seeing a lot of is using big tech to deliver these decisions by proxy through regulation or legislation. Mostly it is with regard to content, but in some jurisdictions, it is also with regard to discoverability or diversity. We wanted to make sure you have a diverse feed, and so we're going to mandate that you show a certain amount of content from Canada if you're on YouTube, or that that idea that other conversations can be discoverable. So I think it's really something that we are very sensitive to, that governments, if you want to have diverse feeds, I can't think of an organization that has more channels on Twitter than the government of Canada or the government of the US. Go ahead, diversify, talk about different things, be more discoverable, but maybe you shouldn't just use us as a proxy for delivering these kinds of difficult messages that you shy away from. And we're seeing this across the world, also with regard to COVID-19. Brazil is a good example on how governments are not taking these decisions, but forcing us to. And then I wanted to just touch on sort of the idea of litigation. The other thing that we're fighting a lot is the notion that these difficult decisions are not being fully discussed, mostly in democracies, and the attitude is, we'll see you in court. This is going to be very difficult for us, probably great for lawyers on this call, in terms of how governments are shying away from taking decisions that are difficult from a legal perspective, and will fight out the actual difficult stuff in court 3 years later. And so one of the things that we're chewing on is principled litigation, or a principle-based approach to conduct. Passive versus active. And so this is something that is happening to us in real time in India right now, in terms of the requests we receive for content takedown from that government and how we're choosing to go forward. And so there is the notion that we're just a function, and there's just certain things that we do passively, and we're trying to wrap our minds around about what it is that we're doing aggressively through our terms of service, or through our rules, so to speak, that demonstrate that we are principled in our approach to how we tackle issues like free speech, or even child sexual exploitation or copyright. So those would be three sort of legal issues that come across my desk on a regular basis, and that I'm happy to discuss further. Thank you.
Thank you, Michelle. Now I will ask Paul to respond to Michelle, and then tell us a little bit about what you plan on speaking.
I'm sorry, you're asking me to respond to Michelle?
Oh, sorry. Pardon me, not Paul, Taylor. I need a big cup of coffee, and I'm right here. So.
And my goodness, there's lots to respond to there. God, I agree with a lot of what you said, and I look forward to talking about it all. But let me just step back a little bit and talk about how, from my perspective, I see this emerging policy debate around whether and how government should regulate speech that Michelle alluded to, playing out, and some of the real challenges and pitfalls governments, I think, are in the midst of at the moment. So, I mean, first, just as context, though, I mean, the problem here is that there are clearly a lot of bad things online. And part of that is because there are a lot of bad people saying bad things in general. The question is whether there's something particular about the design or the incentives of the places where those bad things are happening online that amplifies them or increases those negative outcomes. And if that's the case, the question is whether existing law and regulations will be sufficient to deal with that increased harm. If not, whether self-regulatory approaches will be sufficient in dealing with that excess harm. And if not, we're in this fairly similar position we've been with all sorts of other sectors of our society. When there are negative externalities that aren't being mitigated by a self-regulation, that is when governments traditionally govern. We do this in all sorts of industries: pharmaceutical industry, the food safety space, the petrochemical industry. I mean, this is a common thing we do. The challenge, of course, is here we're dealing with speech online. And as Michelle says, speech is something different. It is protected in different ways by different countries in very different manners. And so that raises some particular challenges. But the second thing of background here is that the way in which governments have stepped into the regulation of platform companies is not just about speech. They've also begun to try and fix or correct what they see as market failures through competition policy, and we're seeing that particularly in the United States emerge as a major pillar of this agenda. They're trying to make the underlying structure of this ecosystem and these technologies more accountable and transparent. This would include things like data policy laws, AI governance regimes, algorithmic accountability laws, which we're seeing Europe really drive. But they are also starting to regulate speech. And I think they're doing that because speech as citizens is the way we experience the internet. When we see a bad thing as a citizen, we don't necessarily see the underlying structure or incentives that or market failure that might be amplifying that bad thing. We just want the bad thing stopped. And so there's this increasing pressure on governments to step into this space of governing speech, even though it's the most difficult one, I would argue, of those three categories of platform governance. Let me just quickly flag a few sort of challenges I think they're stepping into right now. One is that it's just really not clear what an act of speech is online and where we draw that line. Is it the thing that a user says and posts? Is it the algorithm that decides who sees that post? Is it a recommendation system that recommends a user into a group where that post sits? I don't think we fully know. And different jurisdictions are defining speech in different ways, and that changes the character of these laws. The second is that there's a real disconnect between the ultimate best case scenario for platforms, which is one set of rules for every user on the planet. I mean, that is the ideal. If you are trying to build a company and run a company, most importantly, that's managing the speech of billions of users at scale on a day-to-day basis, you'd much prefer to have one set of rules for everybody. That is not how speech is governed. Speech has traditionally been governed by national governments and is deeply historically and culturally situated. In Germany, Nazi hate speech is illegal. In the United States, it is not. Those are for very particular historical reasons in each, both of whom have the right to impose those speech laws on their citizens. This is further complicated by the fact that it is not just democratic countries that are deciding these speech rules. And it is not just binaries between democratic and autocratic countries. It is increasingly countries that are sliding down a path of illiberalism. And they are in part doing it with these kinds of speech laws that sound a lot like speech laws being imposed by democratic countries. I would include Poland, Hungary, the Philippines, Turkey, Brazil, and India in this. These are all countries that are arguably sliding in a liberal direction, and part on the back of increased speech regulation online. So this puts democratic countries in a very difficult position. Should democratic countries who have every right, and I as a citizen of a democratic country believe my country government has a right to impose its own speech laws that are democratically decided and accountable on me and my citizens, but should I be concerned and should my government be concerned if that exact same legal language and regulatory regime is being replicated for a liberal lens in other countries? So it's a real fundamental challenge I think democracies face. So I think we'll probably talk a little bit about how some of this is played out in Canada. I can just for a second summarize the debate of the past year here in the speech space. I mean, there's two initiatives the federal government has been engaged in. One, Bill C-10, which people on this call will be more familiar than with but began as an effort to sort of modernize Canadian broadcast policy. The challenge being that if cultural protectionist policy, whether you agree with it or not, simply isn't applicable in the current way in which we consume culture. And therefore, either you have to get rid of it and say it doesn't matter anymore, which is probably more in the camp I'm on, or you need to update it to be relevant in a platform ecosystem, which is the choice the government made. They got into this, originally this was not going to be I don't think was intended to step into the debate about regulating speech. But they made some changes to the bill towards the end that their rationale is that it was to include YouTube music in this regulatory regime, because a lot of people get music on YouTube and they kind of somehow overlooked that in the first version of the draft, which all of a sudden got them into the space of regulating user-generated content. And they started including conversations about discoverability in the regulation. Discoverability being how the algorithms which decide what gets seen and what doesn't get seen in user-generated content platforms, which arguably, if you think algorithms are speech, which I actually don't think some of the opponents of the bill actually think, gets into speech territory. So we can talk more about what that bill does and doesn't do. But what the irony of this, and I'll leave it at this, is that a lot of concern about the government regulating speech via this bill is unfortunate in my perspective, because they're actually developing a bill that explicitly governs speech at the same time. And this is an online harms bill, which looks at regulating the takedowns of hate speech in all sorts of ways. And we actually might see a version of it in the next few weeks. And I think we are about to head into a period where we have a very public debate about whether we as a society want new rules for how platforms treat this speech that is already illegal in Canada. But we can talk more about where they're going with that and what some of the concerns of it might be.
Thank you, Taylor. Now I will turn it over to Vivek.
Thank you, Heather. I am delighted to be here today, and I find myself in the jointly fortunate and unfortunate position of going last. Fortunate because I have absorbed so much from my fellow panelists. Unfortunate because they covered some of the ground I was hoping to cover. Nevertheless, I think that's sort of good, because it suggests that we identify the same basic problems in the same kind of problem space. I want to build on what Taylor said and pull us back a little bit, right? And I think there's sort of two questions that underlie everything we've been talking about today, right? I think one is a question of, what are the optimal interventions that we should be undertaking to maximize the enjoyment of the right to free speech, or free expression, as I would call it, in Canadian international human rights law online, at the same time as we minimize the bad stuff. And then the question is, well, who should be doing the intervening, right? And the two questions are really deeply interrelated, and they both interrogate some of the key principles of the law of free expression as it's developed, first, I would say, in the First Amendment jurisprudence in the United States, and over the last 60, 70 years internationally, right? Following the Universal Declaration of Human Rights, the International Covenant, the European system, and ultimately, we see structurally similar protections for free expression in most countries with modern constitutions, right? So one of the real difficulties we face, right, is in regulating online expression. There's two. There's a jurisdictional problem that Taylor spoke about, right? How far can I reach, actually, when I'm dealing with an international internet? How far should I reach as a matter of comity and good public policy? And then ultimately, what kinds of speech can I, as a government, regulate? And one of the key problems that policymakers are facing is the so-called lawful but awful problem, right? Which is a lot of expression in a lot of places is legal, right? The law criminalizes, at least in a democratic rule of law society, what's actually banned by law is pretty small. It's a very small proportion of what we would view as harmful in many different ways. Yet we want some action against this. So that it kind of sets them an answer to who acts, which is that the companies for better or for worse, need to act, because most laws that we could conceive of that would deal with the lawful and the large lawful but awful category, and we can discuss what goes in that category, are very difficult for governments to enact, right? So platforms face the need to act against it. And then we have a diversity of platforms, right? Some of which are more socially responsible than others, some of which take their human rights responsibilities as reflected in the UN Guiding Principles on Business and Human Rights, which encompasses the whole of human rights, right? Not just protecting free expression, but other things like equality. They take those seriously, but we also see there are outlier platforms, the GABs of the world, when they existed, that don't take those responsibilities seriously. So we have a problem there with regard to, what is it, who acts, right? And then to pick up on a point that Michelle made, there's also a question of what's the optimal action, right? Taylor mentioned that, what we see online, all the bad stuff, is a reflection of the, what Immanuel Kant talked about, the crooked timber of humanity, right? Nothing straight has ever been made of it. So we know that, people offline have expressed terrible thoughts, and they continue to do so. They always have, they always will. We will always find that online. So the question is, given some of the legal limitations that we face in rights-respecting democracies around what we can regulate, what are those interventions? And one of the places where I think the law everywhere is very underdeveloped is precisely on these questions, right? So we have a well-developed law of broadcasting in many different countries that holds that governments, democratic ones, can intervene quite a bit in what's broadcast on the airwaves for public morals kinds of reasons. Take nudity, for example, or violence. You can't broadcast that during the daytime, but you can show it on cable TV, right? And the idea there is, well, it's not pushed into your house in the same way as a cable package where you subscribe to it, right? But that's a really imperfect analogy for what's happening online. And Taylor talked about the bill that's pending in Canada, right? Bill C-10, which kind of tries to do a root and graft transplant of the broadcast regime into the internet space, which is fundamentally different, right? It is just a completely different kind of medium with different kinds of communication happening. But we don't really have good legal doctrine to guide us on what kinds of obligations are constitutionally permissible to be placed on the new gatekeepers, to use the title of Kate Klonick's amazing article on the Facebook Oversight Board. What can they do, right? That space is undefined. But the other question is, what are the appropriate interventions, right? Is it the simple binary on or off, right? Or do we undertake some more sophisticated interventions, right? Do we demonetize content? Do we make it less prominent? Do we have, for example, there's an entire literature that is emerging on so-called good friction. Maybe we don't do anything other than to slow down the distribution of certain kinds of content by certain kinds of people to slow down its virality. That could be a very effective intervention, but we don't know. We haven't studied it enough. But it's not clear whether, how, and if governments are able to regulate in those spheres, right? So we need a lot more development of the law, but I would say, given the urgency of the challenge we're facing, and also the international issues that are at stake, Taylor, I think, really highlighted an important issue, which is that we have a global internet, and we have illiberal governments watching what liberal governments do, democratic governments do, and copying and pasting that towards their own ends. And we've seen this time and again. Germany's network enforcement law is being used by countries like Pakistan to justify very structurally similar laws that achieve their own illiberal ends, right? So, part of this debate needs to be, one of methods, right? Of who does the regulation, but also how. And I personally, I think that the internet has, on balance, and social media and the liberalization of expression that we've seen has been a good thing for humanity. And it's interesting that President Biden has made democracy promotion and sort of the restoration of democracy as a major, initiative of his presidency. And I would really like to see the community of democracies come together and come up with a common approach to the set of problems that preserves the global internet as a rights-respecting space, and is able to sort of go back to the authoritarians of the world and say that, your methods and objectives are not actually valid, right? That we can rely on international human rights law to achieve those objectives that I do think are very important. So I'll leave it there.
That's great. Thank you, everybody. There's a lot in there. So before we turn to questions, I thought maybe we'll just see if Paul or Michelle wanted to respond to anything from Taylor or Vivek. There's a lot of content here.
No, I mean, I would, the questions that our professor friends are raising are all very important questions. I don't have an immediate, overall response, other than the fact that I think we've had enough experience with the social media platforms to date to say that, that they are not adequately self-regulating. The notion that the industry will take care of these problems itself, I think, has proven to be not correct. The platforms have themselves tried to take additional steps, but I think inevitably governments are going to be circling around this industry, and therefore we have to talk in practical terms about better and worse regulation, not regulation or no regulation.
And maybe I can just weigh in on a couple of things. Taylor talked about the idea of speech. The most speechy social media platform is Twitter, right? Virtually everything on that is the written word or the spoken word. I wish music was posted on Twitter, but it's not. So Twitter gets a lot of the free speech discussion. And then Vivek talked about friction and nudge theory. And those you can see on our platform, we're experimenting with those a lot. And mostly you'll see that as a product solution, right? So nudge theory, you will see if you decide to retweet a newspaper article and you haven't read it, we post a little post saying, do you maybe want to read this first before you retweet it? And you're going to see that actually going forward with us for language. We will use machine learning to detect language and say, you sure you want to tweet that? So we will use nudge theory in as a product solution. And then friction you're seeing all the time with us, where we put up interstitials is what we call them, right? And so you saw that with the Trump account, right? Before you proceed, you need to know that this is what we've done with this. But you'll also see it in terms of if you're looking at a tweet and you scroll down and it says, would you like to see some more tweets? That is our knowledge that as you go down into the, or sorry, it's replies. Would you like to see more replies? As you go further down into the rabbit hole, content probably is worse. And so we are putting up that friction by just simply asking, would you like to click here and see more? And we live in the digital age where just that action, that taking that extra action of clicking is a big commitment. And so that friction is up.
That's great. I love using the behavioral science to regulate speech as opposed to the formalistic rules. So everybody sort of touched on this, and as this is a cross-border panel, with global platforms, and this is a question for you, Michelle, and one I imagine you deal with pretty much all day, every day, but being a global platform, content regulation, it's not just, as Taylor said, sort of nation specific in terms of how people view it. There's also cultural differences between countries, right? And we're seeing it on this very panel with the US, Canada having different perspectives despite being, long allies, and as far as I know, having a mostly peaceful border. So we even see these free speech issues very differently. And as you mentioned, Michelle, governments can ban Twitter, and we've seen Twitter can ban politicians too. So, between those two extremes of total bans and prohibitions, how do we kind of navigate those cultural differences with a global platform? I mean, is Twitter expected to have people in every country with local language and cultural expertise and nuance, or how do you manage that?
So one of the most practical ways we manage that is country withheld content policies. Every digital company has that. So 2 examples, it's illegal to criticize the monarchy in Thailand. And so we have to live within the laws where we operate. In Canada, a little different. I mean, cannabis is legal, right? And so you can advertise cannabis, and you can't do that in other locations. And so, that's actually two really good examples. Whereas the criticism of monarchy is speech, the sale and distribution of cannabis is not, but it is country withheld content. And so, we're all sort of used to dealing with country withheld content. The issue is, context always is important. And I always talk about gaming as the perfect example here. It doesn't even matter, even whatever the regulation is, we do need context. I mean, there's words even in English in the United Kingdom that are used differently that they are in Canada, the United States, right? What would be considered offensive language in the UK may not be considered offensive language here, and vice versa. And gaming is always a struggle for us, because if somebody in the gaming community came after you as a gamer and said, listen, I'm going to kill you tonight, it's going to be ugly and awful, that might be very well received in the gaming community as a wonderful way to engage and connect. And so, while sure, we would love to have some sort of simple, easy solution, it's not there. It will never be there. What we're asking for is, if we do have a solution in one country, we don't really explain to us why we need to tailor it to another country, right? And it's the same, actually, Paul talked about the Section 230 stuff. The states in the United States are doing a lot of heavy lifting on this kind of thing, even I would say more than the federal government at this time, although I'm sure we'll see it with Congress. So we realize there are political points to be scored here too, right? When somebody introduces legislation and wants to take credit for it. But if the political advertising policy is working well in the United States, why can't it just be adopted by Canada? Or why can't it just be adopted by the United Kingdom? Why must there be another second set of regulations? So we think of it as smart regulation. So we'll never escape the importance of context and local law, but we don't necessarily understand why you have to Canadianize something or Americanize something just for the sake of saying we took action against big tech, when it's almost an off-the-shelf solution exists. Can we not just use it?
Can I jump in with one additional thing there? I mean, so look, I totally agree. I think there's some issues in which we're going to see real collaboration between, and I hope we see more collaboration between particularly democratic governments, as Vivek mentioned, to standardize some of this regulatory response. I think we're starting to see it on tax policy with the OECD announcement around a 15% corporate tax. I mean, that's a great example where it does not make sense for everybody to be taxing different rates and all companies to be based in Ireland as a consequence. So it's kind of a collaborative solution to a collective action problem of governance. There are some things though, and I think speech is probably one of them, where we're going to see more differentiation between national approaches. Just because, as I mentioned, there's such different historical contexts for speech law in different countries. And the First Amendment in the United States is a great example of that. That is simply not going to be adopted. That approach to speech governance is not going to be adopted by most European countries, for example, and we shouldn't expect it to be. But the other complication with the international aspect of this, or the global aspect of it, is it leads to very differential self-regulatory approaches by platforms themselves in different countries. So it's not just the different regulatory approaches from governments, but it's also how self-regulatory content moderation policies are applied differently in different contexts. And one of the things we've seen, particularly with the way content moderation resources are allocated, is they end up being over-allocated to Western countries, European and North American, and less so to countries with either less potential value, more complicated language situations. So you end up with this real disproportionate allocation of resources for the very positive and legitimate content moderation policies that are being used in other contexts. So it's kind of two sides of this, right? That there's all the things governments are enforcing, which they're doing in different ways in different places for either democratic or liberal ends. But then there's just the pure resource thing. Is like, does Facebook have the resources to moderate content in 4,000 languages for 100 billion pieces of content a day? At the moment, no. And those resources aren't being allocated in accordance with the user base. They're being allocated in different ways. And I think that's another challenge.
If I could just build on that point, I mean, I think there is, first of all, I think there's a middle ground that we haven't acknowledged between platform self-regulation and government regulation, which is multi-stakeholder regulation, which is one of the most distinctive modes, longstanding modes of regulation on the internet, right? Which is that it's in between. And I've been, throughout my career involved in an organization called the Global Network Initiative, which has been very instrumental in trying to get companies to protect the free expression and privacy rights of their users in operating in difficult environments, right? And the lodestar of that initiative, like many others, is international human rights law. And this is Paul's expertise, and I'd love to hear him speak more about it, being at the Stern, at the Center for Business and Human Rights. But I do think that if we take the business responsibility to respect human rights seriously, right, that gets us a lot of the way on a lot of the things that we're talking about, right? If businesses have a responsibility to respect the right to free expression, as that's defined in international law, which does recognize that there are reasons to restrict expression, right? And I think the Facebook Oversight Board jurisprudence, as it's developing, is quite interesting in that regard, right? In recognizing when it's acceptable and not. But also, a big part of the business and human rights edifice is the idea of due diligence and of companies looking for their most salient human rights risks. And to Taylor's point around misallocation of resources, right? An approach that's focused on business and human rights could help to correct that by, getting companies to invest what's necessary, number one, and number two, to prioritize, right? Not on the basis of political expediency, but on real risk to people, right? And I think that's something we're learning out of the experience of Facebook in Myanmar. And I think the great work that's been done on the failure that happened there and what can be done to avert that in the future.
Thank you, Vivek. Switching focus slightly from regulation, I'm going to ask a question of you, actually, Vivek. In 2016, Facebook banned an iconic Vietnam War image based on regulation of pornography. Now, this was a very well-known image of the naked 9-year-old girl running from a napalm attack. And Facebook reversed its stance very quickly after significant criticism, stating that because of its status as an iconic image of historical importance, the value of permitting this image outweighed the value of protecting the community by removing it. So my question to you, Vivek, is would you say that public pressure influences social media regulation of content? And
the answer is unequivocal yes. But of course, public pressure influences all regulation, right? Governments too. And I've even known some courts to be influenced by public opinion, right? So, there's a few things in that example that are worth looking at. One is that content moderation at scale is really hard, right? When you're talking about billions and billions and billions of pieces of content being posted every day, and judging them on various kinds of standards. Mistakes are going to be made, and any large system has an error rate, right? The criminal justice system has appeals for that reason, right? Because we get it wrong, and I think that's a good sort of process point that's occurring. So, you're going to get things wrong, but the other question is, what's the right answer is also really hard, right? The number of 5-4 Supreme Court decisions on free expression issues on both sides of our shared border is very large. And, I think the same thing is true, even when you have a well-defined moderation policy, right, is that the call on any individual issue can be quite difficult, right? There's going to be a large number of things that are easy, but there are going to be those very hard calls, and people are going to disagree on them. So, that's sort of another part of the regulatory design is, in the European human rights system, there's this idea of a margin of appreciation that governments have a bit of wiggle room in complying, right, to reflect their policy preferences. So the question is, what does the regulatory landscape look like that does permit, that wiggle room to happen, and for platforms to have different views on, what it is that they should carry and what they shouldn't.
That example tells us a couple of other things too about regulatory approaches to content moderation. The reason it was flagged, that was flagged, was because even Section 230 and the First Amendment are not absolute in the United States, and FOSTA and SESTA made exemptions for child pornography and enforced them very aggressively on the platforms. So there was already a kind of regulatory push to flag that kind of content. And that also leads to something we've seen all over the world, which is over-censoring in response to regulatory penalties, which we've also seen in Germany with mandatory takedown rules. There's no incentive for platforms to sit in that gray area. There's an incentive to over-censor. So I think that's an example of that as well.
So picking up on that theme of regulation, Paul, one of the recommendations in the white paper that you referenced is about reform of Section 230, and it's formerly a little known law, but was sort of thrust into the limelight by President Trump. And the suggestion from the paper is basically to keep the liability shield for tech companies, but with particular exceptions, and one of them being civil rights infractions. Of course, with speech, the devil is in the line drawing. So how would you define a civil rights infraction? And, if that were to be a valid exception, and this were to be sort of a path that people could take forward, and assuming, something were to pass in Congress and all the other realities, but how would we define civil rights infraction?
Well, I think in that instance, it would be defined the way existing United States law already defines it. Creating a carve out for civil rights actions does not mean that anytime someone alleges a civil rights action, the platform company in question is liable. It means that you can move forward with a civil rights lawsuit against a defendant who presumably has said something that is related to discrimination, and a court of law would adjudicate that. What Section 230 does is it truncates that lawsuit. There's a Facebook or Twitter or anyone has a defense early in the proceedings saying, apart from the merits of what we're being sued over, Section 230 precludes this lawsuit. And we're suggesting that in certain select areas, that type of truncation would not happen. And that in turn would create an incentive for the platform companies to be more vigorous, more vigilant, at least in those areas. And that incentive to police their platform more aggressively, make sure that content on it meets their own community standards, would be salutary overall. So I don't think that civil rights infractions would have to be defined in a bill. You would just say that category of lawsuits would be allowed to go forward.
I have a question for you, Taylor. And this is regarding the issue of truth and morality. So researchers have found that just 12 people are behind 65% of the misleading claims and outright lies about vaccines on Facebook, Instagram, and Twitter. And these platforms have responded by taking steps to label misleading posts. I think Michelle referred to the labeling of posts, placing restrictions on them and removing those that are false. In some cases, they have also banned repeat offenders. Given that vaccinations are critical to getting the pandemic under control, many argue that those who engage in spreading harmful disinformation about vaccines, as opposed to merely expressing negative sentiments about vaccines, should be deplatformed. So I'm only just using vaccines as an example. My question to you is, should social media platforms simply be a marketplace for the exchange of ideas without content moderation? This is going back to the idea of free speech. Or should they be arbiters of truth and morality by weighing the costs and benefits of permitting false content, such as, for example, disinformation about vaccines, denial of historic events such as the Holocaust, or content that promotes hatred and violence?
Geez, I mean, that's a big question. I mean, I think we have landed on the latter. Platforms make decisions all the time about speech, about the character of speech, about what's incentivized, about what is where friction is added to, which I think is a really healthy development in this discourse. Things like anti-vax content, though, or even vaccine skepticism presents real challenges here. I would not want to be in charge of the decision over what is considered anti-vax and fundamentally harmful and disinformation, and what is skepticism of science and government. Those are two, in many ways, very different things with a lot of gray area between them. So this is a very difficult situation. And I think in all likelihood, we will end up in a place where more burden is placed on companies, more transparency is demanded by governments in how those decisions are made. And there'll be a desire for more friction in that process for certain types of content. That is a very different question around that mis and disinformation space than the one about illegal speech, which is, I think, is where a lot of the regulatory approach from governments is targeted. And like Michelle rightly says, governments are very hesitant to get into this at all. I think their hands are being forced on illegal speech, and we're going to see the emergence of all sorts of regulatory regimes to enforce takedowns around illegal speech. But I think they're even more hesitant to get into the mis and disinformation space. And that will likely, in all likelihood, remain a burden that the platforms have to bear. I don't see any outcome from that. No, and market pressure is deciding some of that too. I mean, as Vivek said, one of the real reasons we've seen a lot of change here is because public attitudes have shifted on this stuff. People don't want to be surrounded by this kind of content, and they're expecting more from platforms to clean it up and to deal with some of these problems. And that's a good thing.
Let me ask a question for everybody, and maybe Michelle, you want to take the first stab, but anybody jump in. When we're talking about sort of policing and enforcement, there's really, to me, two pieces to it. There's the prevention policing of what's prohibited at the outset, and then there's the sort of after the fact banning and those kinds of remedies. But of course, hindsight is 20/20, right? And you know the context after the fact. You know what's happened or didn't happen as a result of particular speech. And so how do you sort of balance that challenge that after the fact, you have context, but it's possibly too late to do whatever sort of preventative measure you're aiming for? How do we find a way to strike that balance? It's obviously something that when government is doing enforcement, it always has to come after the fact, right? And you're always looking backwards, and sometimes it's years after the fact. And so the effect, certainly from a public policy or public view opinion perspective, is that it's sort of limited. So I'm interested in how do we balance those two things?
Yeah, and add dissent into that, right? Dissent sometimes confused as misinformation. Great question. How much time do you have? Obviously, one of the things that we rely on is, because Twitter is public, people run to the fire. And so a lot of these, at least on Twitter, come up to us very, very quickly. And of course, the decision needs to be taken in real time. It's certainly a struggle from a resources perspective in terms of how to manage that. We haven't figured it out. A lot of times we do rely on users to come and join the conversation and help solve it. Otherwise, we have reporting internally. We have, anybody can report something. And then after that, there's the level that you get to, which is deplatforming. And deplatforming is a big deal for us. We really, really struggle with it. We have not traditionally felt comfortable deplatforming people. We're doing it more now as we refine our terms of service, and as we get more information globally from centers like what Paul has, people giving us information about what's happening. You talked about the 12 anti-vaxxers, the Big 12, the Big 10. So a lot of that informs our ability on whether or not to act, but also the A lot of it is informed by the user, the account holder, right? If they have repeatedly violated our content policies, at some point they will be deplatformed. But it is scalable, right? The first thing that you usually see is that we ask them to take down the tweet, so you can't see the tweet. The second thing is we lock their account. And then if it's really egregious, we take them down. We also, then of course there's the legacy, right? And there's two great examples, which is the New York Post article and our world leaders policy under which we actioned Donald Trump. So I think that Jack Dorsey has appeared in front of Congress multiple times and talked about how he struggled with it and how unhappy he was with the outcome. And so how do we learn and grow from that? So we've gone through a massive consultation for our world leaders policy. We're in the middle of, I think we received like 20,000 submissions on that policy alone. So we do go out to the street, so to speak, and say, help us with this. Our synthetic and manipulated media policy is the other one, which was under what we actioned Donald Trump a few times as well. And then, the second, I mean, the most obvious one is the New York Post one, where we blocked them, and then we realized that we didn't have the right information, and so we unblocked them. And so it's not easy, it's not pretty, it's very fluid. We do our best to make it consistent, and we do our best to talk about it publicly. Those are our commitments. But we do make mistakes, and the interesting thing on dealing with governments is that governments oftentimes feel they don't. And so when we come out and say, listen, we made a mistake here, the governments will pounce on us. But when governments make mistakes, they don't. So the good example in Canada being the initial advice we received with COVID-19 that masks were not needed, which could nowadays be completely characterized as misinformation and get you sanctioned on Twitter. So we rely on reporting. We do rely on people coming running to the fire, and it's been very interesting for us for COVID-19. Anti-vaxxers will tell you that sometimes the decision to take a vaccination was made not because their doctor told them to, but because they engaged with somebody online or in the playground, right? So we want to make sure those are opportunities to learn and grow. And then there's our policies, and then there's owning up afterwards, which is what happens to us daily.
We have a question from the audience, which is a fairly long question, but I'll read it out to you, and any of the panelists can answer this. It says, this is a provocative question to elicit debate. One could disagree with Owen, that's with Taylor, that social media is like any other major industry that's faced with challenges regarding public interest issues, including speech. With mega platforms like Facebook and Twitter, the reality is that we are dealing with what are essentially a form of global governance entities with massive economic power, with their own bills of rights, aka community standards, and potentially so powerful that even the most powerful governments may not be able to fully regulate. So how does government, civil society, or enforcement agencies start to impact effectively to prevent the global bads? Example, preventing hate speech that can morph into genocide, but not interfere with the global goods, including freedom of speech that is essential to democracy.
I mean, I can just say that my point was that they're not like other industries because of precisely that reason. We're dealing with speech, and speech is fundamentally different than other industrial sectors. That being said, if you look at the broader platform governance agenda, some elements of it are much more analogous to how we regulate other industries. Competition policy, for example, updating tax laws, all of these things are things we do in other sectors all the time, and we know what market fairness looks like, for example, and maybe we need to update our measures of market fairness for the digital economy, but that's not an unreasonable thing to do. Regulating data flows across borders and the way data's stored and treated and via various privacy regimes is not an insurmountable thing to do. Providing a bit more transparency into the system, as we do in the financial sector, for example, isn't unreasonable to think we can do. But the speech stuff is different. And in my view, it's therefore the thing governments should probably be doing last. If I were designing an approach for a government in this space, I would probably say, do those other things first and then see what happens to your speech problem. I bet a lot of those things are gonna fix some of the negative things you now see with speech. And if they don't, then maybe you can take some of these more controversial and difficult regulatory approaches once you know what's left of that speech problem. My strong suspicion is some of this stuff is going to help what's currently seen as a challenge of harmful speech.
If I could add to what Taylor just said, I think something that we're increasingly starting to study and understand is the speech privacy nexus. That the two things are very closely related in ways that sometimes are obvious and sometimes not. So to sort of give a concrete example of how privacy reform might solve some speech problems, I mean, to the extent that targeted distribution of content is a problem, right? That's because of the amount of data that platforms collect and the way that they use it to target different kinds of content and advertising at different kinds of people, right? So stronger privacy regulation may help with that, right? At the same time, people are talking about doing some very privacy invasive things to deal with speech problems, So in Canada, there's a bill before the Senate, that is trying to stop young people from watching pornography that is basically proposing to collect facial ID information of every internet user in Canada, if you read it some ways, right? That's a huge privacy violation to deal with a content problem, potentially. That bill doesn't seem to be going anywhere, but it's an example of the interrelatedness of some of these issues. I also wanted to add another point, which I think has been sort of floating underneath this discussion, which is that one of the real challenges in regulating platforms across all of these different public policy areas of concern is that they're not just one kind of business. They do a lot of different things, right? So Facebook, right? I mean, apart from the integration of WhatsApp and Instagram, let's just take the Facebook platform itself. When a political figure speaks on Facebook and Facebook distributes that content, they're analogous in some ways to a journalistic organization, especially when they fact check it, right? When I message someone, they're acting a bit like the phone company and running an SMS service or, Twitter direct messages, right? So there's a lot of different functions embedded into these platforms. And, if we're going to regulate them appropriately, we need to disaggregate those different functions. And some of them might be treated differently by the law, right? So the idea that, again, and this gets into non-binary policy, right? The simple up, down, yes, no, legal, illegal, take it down, keep it up, right, is not nearly sophisticated enough to deal with the kinds of impacts that platforms have because of the range of services that they provide and the way that they're enmeshed in people's lives.
Thanks. So I think that's a good transition. Nothing in this space is binary. So I'll ask a question, maybe sort of in a poll-like way for all of the panelists, and think of it on a scale rather than binary. Is there a point at which, or to what extent, if any, are the social media platforms basically becoming like the public square in the sense that we should then view the free speech or First Amendment in the US jurisprudence that we have as applying to them because they are not the phone company, but a public square? Is where are we on that sort of continuum from no, never, yes, absolutely, now, yesterday, or somewhere in between? Paul, would you like to?
Sure. Unfortunately, this might be a mushy answer, but I think they're in between. I mean, I think they have elements of editorial control that make them, in certain contexts, at certain moments, seem like a newspaper website making lots of decisions about what does or doesn't appear. At other moments, if you're talking about the messaging service, they seem kind of like a telephone company, but they're neither. And I think they've conceded that. And I think as a result, we need to approach the idea of regulating these spaces cautiously because of the danger of impinging on speech, but recognizing that both in terms of the companies regulating themselves and potentially outside bodies, government bodies, that we need to address the problems that have cropped up. We can't just look away from it and say the marketplace of ideas will take care of it. So I vote for in between.
In between for one. Taylor, what's your vote on that scale?
So I absolutely agree that they are multiple, most companies are multiple things in different ways at different times based on different functionality. There is an approach where you could regulate that functionality based on the analogies to previous systems. You just have to do multiple things to multiple companies. I mean, when is Facebook's newsfeed algorithm similar at making editorial decisions and therefore should come with certain forms of responsibility and liability for that decision making? Maybe, maybe not. If Facebook hires journalists and pays journalists to produce content for its site and then publishes it, that's starting to look a lot more like a publisher. So maybe that function brings with it certain responsibilities. So look, I think the argument that platforms are unlike any one thing we have experience governing does not mean we shouldn't govern. It means we should look at the different functionality, see where those analogies apply, see where there's precedent that could be applied to those. And if they don't, then we can start talking about what new regimes might look like. But some of the stuff does translate.
Michelle, you have thoughts on that question?
Well, I like everything that's said. Let me just add sort of three things to it. First of all, I always say that choice is baked into the system anyway. Like, you don't have to use Twitter, and lots of people don't, right? That's why we're not as big as Facebook or Google. So, you can not use us, and while you're on the platform, you can not follow people and block people and all those kinds of things. So the first thing is to think about is choice. The second one is I do have to make a comment on politicians, generally speaking. I do think that, we often talk about at Twitter how, to use Game of Thrones, winter is here. Politicians do love to campaign against big tech, right? It's a lot easier to campaign against us than on your record. And so there is a little bit of political stuff that is baked into all of this conversation. And then finally, I just wanted to talk about, just to say, regulation and competition, I think, are two really important things. As the number of companies get really, really big, they are begging for regulation on these kinds of things. And that's one way to stop competition. Compliance with regulation and these guys is really tough, and it's going to be tough, especially globally. So I agree with a lot of what Paul said, in that we do find we are in a different space. We are oftentimes a behavioral science company that does sales than always a free speech company. So, these are really tough questions, but if you don't like us, don't use us.
That's great. Vivek, where on the scale do you fall?
So I agree with everything that's been said. I'm just going to reframe the question slightly, right? Which is that the First Amendment is a really unhelpful way of thinking about platforms, right? Congress shall make no law, right? Interfering with speech, right? It's the thou shalt not. And of course, we know that there's all kinds of exceptions, right? Time, place, and manner, et cetera, for our First Amendment friends. Right. So I think free expression law, as it's evolved in the post-war period, is the better way of thinking about this, because there's a presumptive right to express yourself subject to reasonable regulation, right? And you need to meet the three-part test in international law and similar tests in other countries of necessity, of proportionality, and rational relation of means to ends, right? And I think that's where the oversight board is really interesting, right? If we take seriously the idea that platforms have human rights responsibilities, one of them is to respect free expression, they need to show that their limitations on it are justified, and that justification changes depending on what exactly they're doing, right? So again, we talked about a lot of different kinds of of activities that platforms engage in. And I think, you know, the measures that they take vary, right? So they do look like common carriers in some aspects of how they operate. And that actually raises some difficult questions. You know, we have this interesting conversation about WhatsApp, right, and its role in fueling disinformation and violence in lots of places around the world, India, Myanmar, Sri Lanka, Kenya, etc. But, you know, we don't have that same conversation about the sort of cellular phone company operating there, which has a, you know, similar role in spreading information, right? Or we don't look at the mainstream news media or the fringe media that is spreading misinformation and disinformation through those same lenses, right? So I think, and that's another point, right, is that the companies don't exist in a vacuum. They reflect society and they reflect what other forms of media do, right? And we know this a lot in the disinformation space from the study of what happened in 2016 by Yochai Benkler and others, network propaganda. So, you know, I think regulating platforms according to their functions, but also understanding the social role that they play in a larger ecosystem is important.
Heather, I don't know if you have another question or maybe.
Yes, I think we do have time for another audience question. And I'm going to open this up to the panel, maybe starting with Taylor. May there come a point at which social media platforms function so much like the public square, the marketplace of ideas, that at least in the US, they ought to be viewed as a public forum and subject to First Amendment cases and doctrines? So that's a question from our audience.
I mean, I think that's what we were just talking about, right? I mean, I think at times they are like public squares, absolutely. But no, I think that's basically what that previous conversation was just about. That at times this functionality is there, and and this is a function of largely transferring some of the public square onto these companies, and sometimes they function quite differently.
As long as we're talking about whether to apply the First Amendment to the companies, it's worth remembering that if you think it through, I mean, the companies themselves, Facebook, Twitter, et cetera, themselves within the US legal system have First Amendment rights to say and amplify and do things that they want to do as they want to do them. So it's not just, applying the First Amendment to these companies does not necessarily paralyze the companies from doing content moderation. Maybe the opposite. Maybe it liberates them to do and say whatever they want.
Yeah, I'd agree with Paul. You know, I think there's a lot of people who love the Pruneyard case in Marsh v. Alabama and all these, company town cases where, private property was held to be a First Amendment public forum, but they're just not the same, right? I think platforms are influential, but they're not a public forum, right? They're private spaces that have rules, they're important, very important private spaces. And that's why I think that international free expression law should govern how they moderate. But we could say that the internet itself, right, the whole medium is the analogy, right? And that's where, at the sort of communications layer, where the First Amendment claim applies, right, where state action, should be prohibited that prevents people from saying things that are constitutionally permissible online as a whole. But then we're talking about the common carrier, right, the regulation of the common carrier that's moving the stuff, the packets, from place to place.
Michelle, do you have anything to add?
No, I'm good.
Great. So look, we've got about 5-6 minutes left. Maybe if everybody wants to give sort of some final thoughts that they have on this robust discussion that we've had, covering the gamut from human rights to everything, everything in between. Should we go in a similar order? Paul, do you want to start first?
Yeah, I think we just happen to be at a really critical moment where decisions like kicking a president or a former president off of a platform is right in front of us, and we're going to be able to judge the results of that. And combined with that, you have both the Congress in the United States in kind of a stumbling sort of way, moving toward regulation, whereas in the EU, I think there's a more direct and more sophisticated process underway that is almost certainly is going to bring interesting new forms of regulation. And it's a momentous time, and a lot of critical decisions are going to be made in the next year or two or three. And I'm glad that smart people people smarter than I am are paying close attention.
Thanks, Paul. Michelle.
Thank you very much for the opportunity to engage with the panelists and everybody here. I'm very grateful. I'm also very grateful every single day to be working for Twitter, and in the middle of these discussions, there's never a dull moment. I guess I would end where I began and said, you know, these are extremely critical discussions that are not new, but are new in terms of how the medium is new, the reach is new, and the speed is new. And so I think that it's extremely important to have these conversations out in the open, to open source these conversations, to rely on data and to engage. So I'm very grateful for the opportunity to talk about them, and this conversation will continue online.
Oh yes. So yeah, thanks everyone. That was a great conversation. I really enjoyed it. Look, I would just say we end up in this broader conversation about how to govern technology and how to govern big tech and platforms. And looking for these silver bullets. Like if we just made one piece of speech illegal, we'd solve the problem. If we could just get rid of Section 230, it would solve all the problems. And the reality is these companies are so embedded in our lives, in our society, in our economies, in all different ways, as Vivek said, that it's going to require a pretty broad agenda. It's going to look different in different places, in different countries, in different contexts. The problem is governments are just really bad at that kind of regulatory multitasking or governance multitasking. But that's what we're going to have to demand of them at this point. So I hope we can just encourage thoughtful conversation from governments about some of the things they can do and some of the downside risks of things they might be tempted to do. And hope this conversation gets better over time.
Yeah, I'd also like to thank everyone for a really rich conversation today. You know, I think these are difficult issues that don't have easy solutions. If they did, we would have found them by now. But I think in solving some of these challenges, the question is, you know, what are our priorities and what do we value the most? I sort of grew up with the internet as an open global communications network, and I think it's been, again, a great thing for humanity. That it has sort of unlocked a lot of human potential and created a lot of good at the same time as there are some harms. So I think there's a question of, you know, how do we preserve what's good about it, you know, without throwing it asunder, right? Babies, bathwaters, et cetera. And I mean, this is where I really think that at this moment of peril for democracy, it behooves democratic nations to think about not just what they regulate or, you know, but how. I think the how is more important than it's ever been. In this space, right, to make sure that we do preserve that open space for discussion and, you know, create the greatest possibility for the enjoyment of rights online. So thank you.
So I think that has brought our time to an end. On behalf of the ABA section of Civil Rights and Social Justice and the CBA National Constitutional and Human Rights section, I want to thank everyone for joining us for this free webinar. And we hope that you will be able to join us for the third webinar on disinformation and the challenges to democracy, which will take place on June 23rd. There is a link to the web series page in the chat where you can find additional information on this program. And we would like to express our gratitude to our fabulous speakers, Michelle, Paul, Taylor, and Vivek, for an excellent and thought-provoking discussion on today's very broad topic of social media and the challenges and opportunities in free speech. We know how very busy all of you are, so thank you so much for taking the time out of your schedules to share your expertise with us. Thank you also to Claire for co-moderating this webinar with me, and Ali for all her hard work in putting this webinar together and providing us with logistical support behind the scenes. If you are not already a member of the ABA and the CBA, we encourage you to join, because this is a great way to connect with other members of the profession and to be involved in initiatives such as this. So stay safe, everyone, and have an enjoyable summer.
And don't forget to tweet and post to Facebook and Twitter and LinkedIn that you just attended this fantastic panel and debate.
This will not be this content